Hello friends, welcome to CEC Gurukul live lectures. Dear friends, today in this session we are going to continue further in our series on copyrights. In our previous session we discussed in detail on intermediaries liability for online copyright infringement. Friends, today also we are going to talk on the same topic, but today we are going to deal with a case study. And for the discussion we have with us in our studios Dr. Ashwini Sibal. Dr. Ashwini Sibal is Assistant Professor in IP Laws and IT Law in Faculty of Law, University of Delhi, a prolific and a dynamic professor who is always ready to give in-depth knowledge to you on various topics. Friends, if you have any question in mind while listening to us, feel free to talk to us through our toll-free number. Our number is 1800-110-430. I repeat, our number is 1800-110-430. Now, I would like to welcome our guest, Dr. Ashwini Sibal, once again, and would request him to kindly give us more and more information on the respective topic. Hello, sir. Welcome to the lecture.
Thank you, Gitika. Thank you very much for your nice elaborative introduction. Well, my dear friends, a very good afternoon to all of you. I hope you remember that in the previous discussion on intermediaries liability for online copyright infringement, I navigated all my viewers to different provisions under IT Act, under copyright law, in relation to intermediaries liability for online copyright infringement. Today, as mentioned by Kitika, we are going to discuss the case study, which is the recent case study on intermediaries liability for online copyright infringement of year 2016. My dear friends, I will also discuss a very recent case study of year 2018 of the similar High Court, that is Delhi High Court, delivered this month only, wherein the Delhi High Court has elaborated more on the intermediaries liability for online copyright infringement and has decided a question of liability of e-commerce entities being intermediaries for online infringement of certain things. But that case study is specific to e-commerce entities, my dear friends. So we will take that case study of 2018, November 2018 in the later part of the discussion. But in the first half of the discussion, I would be focusing on the case study which I brought for you, that is Myspace versus Super Cassettes Industries Limited, Delhi High Court 2016. Well, my dear friends, before taking you to the fact sheet of this case, let me first tell you or recapitulate what I told you in the previous discussion about section 79 of the Information Technology and about section 81 of the Information Technology Act 2000. There were two sections that we discussed of the IT Act which have a direct bearing on the issue at hand, that is intermediaries liability for online copyright infringement. I also spoke about section 14 of the Copyright Act 1957 as well as about section 51 of the Copyright Act 1957. So in a way you can say that there are several provisions, few are from Information Technology Act 2000 and few provisions are from Copyright Act 1957, which are required to be read together and which are required to be considered together in order to finally determine the intermediaries liability for online copyright infringement. Well, my dear friends, if you look at the Copyright Act 1957, since it is a special statute for copyright, so in the cases of copyright infringement or in the disputes relating to conferment of rights under the copyright regime, copyright law will get invoked. So we cannot ignore or just segregate copyright law to be invoked in the cases where copyright infringement is taking place, though it is taking place online. So that's why you see, since copyright infringement is taking place online, in the online medium, the law relating to information technology is applicable, but for the copyright infringement, provisions of the copyright are to be necessarily invoked. You cannot just dissect copyright law and rely solely or exclusively on the Information Technology Act 2000. They are to be read together, to be seen together when it comes to the question of intermediaries liability for copyright infringement in internet or on internet in online medium. 7981 of the Information Technology Act, these are the two provisions, key provisions, which I am going to refer to, and we're going to see the application of these two provisions along with 51 of the Copyright Act and 14 of the Copyright Act. So with this background, my dear friends, about the key provisions which are involved or which will get involved in the case study, I proceed ahead with the fact sheet of this case. Primarily, the issue arose in year 2007, my dear friends, when Super Cassette Industries Limited, popularly known as SCIL or popularly known as T-Series, filed a suit against Myspace, a social networking platform, alleging copyright infringement against Myspace. Friends, here the issue arose in 2007 and the judgment on this issue, which was brought to the court in 2007, was delivered by the single judge of Delhi High Court in 2012 initially. After 2012, the judgment delivered by the Delhi High Court single judge bench got challenged before division bench of the Delhi High Court, and the judgment on that appeal against the decision of single judge came in year 2016, and in year 2016 the division bench comprising Justice Ravindra Bhatt and another lady lordship decided, rather I will say they reversed the judgment of the single judge and criticized that judgment heavily of year 2012. We will see the transition, or we will see the niceties involved in that case, but first we are concerned with the fact sheet, where you see T-Series, or you may also call it Super Cassette Industries Limited, filed a suit against Myspace, and Myspace is a social networking platform. Now you need to understand here that Myspace, being a social networking platform, is basically an intermediary here. They are providing some cinefilms, musical works, etc. of Super Cassette Industries Limited to the subscribers of this social networking platform. They are also allowing the users of this social networking platform called Myspace to upload the content on their platform, which can be seen, downloaded, streamed online by rest of the viewers of Myspace or subscribers of Myspace. So this intermediary was alleged to have been involved in activities where Super Cassette's work, copyrighted work actually, was getting infringed. That was the allegation against the Myspace, and that was brought in year 2007. T-Series alleged that Myspace's platform allowed users to upload and share media files which were copyrighted media files of the Super Cassettes Industries Limited / T-Series. Now you see, my friends, those of you who have been listening me in my previous lectures on copyright, they know it categorically that under section 14 of the Copyright Act 1957, right to communicate the work to the public lies with the owner of the work. No other person can, without the authorization of the owner of that work, ever communicate, disseminate that work to the public. It's a prerogative actually which lies exclusively with the owner of the copyright over the work. Nobody else can communicate it to the public. But when you see your work is being communicated without your authorization and consent, you may certainly go for the infringement action against the infringer, against the perpetrator. And this is what has happened as far as the fact sheet is concerned here, that Myspace allowed the users to upload and share media files. The noticeable thing is that in this fact sheet, that users were actually uploading and sharing media files. Myspace just provided the platform and allowed the users to do the same. They never actually uploaded anything and shared any media file on their platform on their own, but their users were doing it rampantly. So here in this fact sheet, one thing is crystal clear, that users who were uploading and sharing media files having a copyright of T-series, they can be squarely made liable for copyright infringement because they were communicating without the authorization the work of T-series to the public. But what about the liability of the Myspace, which is primarily a social networking platform, or you can say an intermediary? They just allowed the users for profit to upload and share media files of anyone. I mean, they never restricted users to upload the media files etc. on their platform of other companies as well. But Supercassets identified that their work is being uploaded and is being streamed, and the files of their work are being made available to the public without their authorization, and they allege the copyright infringement against the Myspace. Now we are here, you see, concerned with the two issues, or if I filter it little more, we are concerned here with the infringement of two different people or entities. On the one hand, we are concerned with the liability for infringement of T-series work on the users who were uploading and sharing the media files. On the other hand, we are concerned with the liability of the intermediary, the social networking platform people, that is Myspace, for any sort of infringement if they can be made liable for that infringement. Well, as far as the law relating to copyright and law relating to infringement in the copyright is concerned, there is a concept of secondary liability under section 51A2, which says that anyone who allows the premises for profit to let the copyright infringement happen and take place can also be made liable for the secondary infringement. So the people who are allowing their platform, I mean in the present context, Myspace was allowing the platform to the users for upload and for sharing the media files, can be booked under the Copyright Act for copyright infringement, which is a secondary infringement basically, for the liability of secondary infringement. But we will have to see whether, you see, Myspace being an intermediary be fastened with this liability or not. Had he not been intermediary, he would have been fastened with this liability outrightly. There is no question, there is no denial about this fact, and it is not disputable at all that anyone who allows the platform for any copyright infringement to take place shall be made liable for secondary liability or secondary infringement. But since here in this case Myspace is not just a normal entity, they are intermediaries and they are just allowing the users to upload and share media files. So in this case the situation would deviate from a general situation where anybody can be fastened with liability for secondary infringement. We will unfold this aspect little later. Let me first complete the fact sheet. Another allegation was that users were sharing Super Cassettes Industries Limited copyright works without authorization. So Super Cassette Industries Limited here proceeded to file a civil suit against Myspace for primary infringement under section 51AI of the Copyright Act, as well as for secondary infringement under section 51A(2) of the Copyright Act 1957. I would request the viewers to pay heed to the last point on their screens, that here Supreme Court proceeded this suit against Myspace for the secondary infringement to be made under section 51A(2) against Myspace, and they also proceeded with the suit for primary infringement under section 51A(1) of the Copyright Act against the Myspace and the users of the Myspace. And it is very tough to sue every user, because there were thousands of users of the Myspace sitting at 1,000 different locations in the world. So all cannot be booked in one go. So that's why you see the suit was filed against Myspace for primary as well as for secondary infringement. Now let's come to the 2012 judgment, which is actually contentious, which is actually impugned, and which was criticized heavily for the want of curtailing freedom of speech and expression. It was also criticized heavily on the fact that this judgment took the internet scenario to several decades back, actually, by curtailing it on every stage, which is not possible in the internet medium. Now let's see as to what was decided by the court in this case. Court injuncted Myspace from permitting any uploads of Super Cassettes Industries Limited copyrighted conduct, and directed the SCIL to expeditiously execute content. Now the point is, my dear friends, if you recall the previous discussion where we discussed about section 79, which in general sense says that intermediary shall not be made liable for any third party data information dissemination in the online medium or on internet. So if we go by section 79 plainly, we find that the intermediaries are provided with the immunity or are provided with the absolute exemption in the first part of section 79. They are provided with the absolute exemption to be made liable for any sort of infringement or for any third party data transmission, dissemination, etc. But here the court injuncted Myspace from permitting any uploads of Super Cassettes Industries Limited copyrighted conduct, and directed the Myspace to expeditiously execute content removal requests. As per the law, information technology law, or under the information technology rules, we find intermediary rules where it is crystal clear that if any intermediary receives any request for removal of any objectionable or any copyrighted content of someone, they have to expeditiously remove that content and have to expeditiously execute that request. And the time period provided for doing the same is 36 hours. So within that time frame of 36 hours, they are supposed to take down the objectionable material if it is objectionable, and if it is something which has to be removed, and or with whom copyright lies with somebody else, or on that particular content the copyright is of somebody else. So in that case they are supposed to or expected to act swiftly, and the court here injuncted Myspace from permitting any uploads. So what does this mean? This injunction means that Myspace will not be allowed to upload any of the SCIL's copyrighted content, but it's not possible for Myspace to follow or to comply with this kind of an injunction. Reason being that internet medium is altogether different, where several people are functioning and using the Myspace's platform, and they're uploading the content from different locations. They cannot be curbed in one go by Myspace, and the Myspace cannot just restrict them from upload of the copyrighted content of SCIL, where SCIL has not even provided as to which content they are talking about. They actually provided voluminous record of or repository of songs, and they allege that their songs are being infringed. They never provided with explicit instances, specific instances of infringement to the Myspace. But despite that, the court here went wrong and delivered a judgment that injunction is made imposed on Myspace, and Myspace was restricted from uploading any of the SCIL's content. Now the court, in this similar matter in 2012 has held Myspace liable for copyright infringement. See, issuing injunction and not allowing them to upload is blatant violation of their right and the right of the users also of getting access to certain things, as well as it is a blatant violation of the freedom of speech and expression, which is a constitutional right, by the way. The court also decided in this case that Myspace is liable for copyright infringement, despite the fact that Myspace was never provided with the specific knowledge of specific instances of infringement of the work of SCIL, despite the fact that Myspace removed infringing content upon complaint of SCIL, and Supercassettes had failed to submit songs to Myspace and the song ID database to Myspace. Well, in light of these things, in light of this, that Myspace was never provided with the specific knowledge of specific instances of infringement, Myspace removed and took down the content which was brought into the knowledge of Myspace by SCIL, so they acted swiftly. Notwithstanding this, notwithstanding the previous fact that they were not provided with the specific knowledge, the court passed injunction, the court made them liable for copyright infringement, and the court choked all the intermediaries across the country to work smoothly, to work fearlessly. Well, there were certain questions which are posited in 2016 in the appeal filed before the division bench of Delhi High Court in the similar matter by Myspace against the order of the single judge bench of Delhi High Court in 2012. The questions which got posited or which were posed here are as follows: whether Myspace could be said to have knowledge of infringement so as to attract liability for secondary infringement under section 51A2. There did not arise a question of primary liability, because the court said that they are not going to listen about the question of primary liability. It is to be decided by the single judge when the matter will go back to the single judge for the decision on the primary liability. But the court here framed a question on the secondary liability or for the secondary infringement done as alleged to be done by Myspace here. The court also posed another question about the proviso to section 81, whether this proviso of section 81 override the safe harbor granted to intermediaries under section 79 of the act or not. Well, my dear friends, I request all my viewers to see this case study in light of my previous lecture or intermediaries. This is part 2. If you will not refer to the previous lecture and to these sections you will not able to understand the niceties. So I request again to kindly look back to the previous discourse, and in the context or in the backdrop of the previous discourse you have to understand all these integrities, all these nitty-gritties basically, where we are concerned with the question of the overriding effect of the proviso of section 81 to intermediaries under section 79 of the Act or not. Then the third question was whether it was possible to harmoniously read and interpret section 79 and 81 of the Act and section 51 of the Copyright Act. As I mentioned in the very beginning of my lecture today, that we have to see some provisions of the Copyright Act as well as of the IT Act in order to comprehend and discern this issue at hand fully. If we don't do that, we won't be able to understand this issue fully. So these three questions on your screen excuse me, were the questions before the Court of Law in 2016 in an appeal filed by Myspace against the decision of injunction and copyright liability made by the single judge bench of the Delhi High Court. It is interesting to note that the division bench of Delhi High Court, my dear friends, while answering these questions, so very pertinent aspects before deciding the matter. They said that despite the fact that Myspace, being a social networking platform, had its user agreement policy, it had some mechanisms opted by them for post infringement removal of the copyrighted content, despite the fact that SCIL had lakhs of songs and material alleged by them to have infringed on the platform of Myspace. The court here, the division bench here in 2016 in the appeal of Myspace, did not find this intermediary Myspace liable for any sort of infringement or any secondary infringement, solely relying on these things that they had a users agreement, they had a post infringement mechanism in operation, and SCIL's several songs got infringed. These things, according to the court, are not indicative at all of any sort of liability which is a secondary liability to be fastened on Myspace. Well, let me provide you little more elaboration on this point. In the previous case, in year 2012, the court, while issuing the injunction and while making the intermediary Myspace liable for copyright infringement, took note of certain facts as alleged by SCIL in that case. SCIL actually alleged in that case that because of the existence of users agreement, where it was categorically written that all the users shall be made liable for the copyright infringement if they will upload anything or if they will download anything which has a copyright over that. The court also took note of the fact that Myspace, being an intermediary, has some post-infringement mechanisms opted by them. For example, blockers applied by them for blocking certain informations, etc. Some filters applied by them for taking down the infringing or contentious objects, or you can say contentious material from the website. So these measures, the user agreement, etc., were read by the previous court as if they had the knowledge of some infringement to take place. Is not it funny that the court is taking note of users agreement and saying that the Myspace, being an intermediary, by just providing a user agreement and by opting some post infringement mechanisms like blockers and filters, knew that somebody's copyright will get infringed, and then that intermediary can be fastened with the liability for copyright infringement. It's really ridiculous, and it's illogical outrightly to say that if I provide a user agreement wherein I tell to my users that if you will do this, you will be made liable. It does not mean that I am also hand in glove with my users. I cannot be fastened with any liability for that. But in this case, the court issued the injunctions and restricted Myspace from permitting its users for upload of any of the copyrighted content of SCIL. In the same case, you see, appeal was filed, and in 2016, court took note of the mistakes committed by the single judge and its, in the decision of the single judge, and the court found that this entity called Myspace, since it is an intermediary, it cannot be made liable for copyright infringement, and they absolved Myspace from any sort of liability for secondary infringement in 2016. They undoubtedly permitted a place of profit. It was said by the court that Myspace provided undoubtedly a place for profit for communication of infringing works uploaded by its users, but it did not have specific knowledge nor reasonable belief of the infringement. And these are the key, points which you must take note of, because these are the exemptions which are provided under section 79 of the IT Act 2000, and in the exemption it is categorically written, my dear friends, that if the intermediary did not have specific or actual knowledge about the infringement taking place, if they have no reasonable belief of the infringement, then they cannot be held liable. Actually, under section 51A2, where a person can be made liable for secondary liability, it has been held that the person had to have a actual knowledge of the infringement. While allowing the place for profit, it is written under 51A2 that the perpetrator has to be found having a specific knowledge, actual knowledge of the objectionable content to be violated or of the objectionable content to be infringed. But in this case it was missing, and even they did not have a reasonable belief of the infringement. So how could they be made liable for the infringement of the copyright work of SCIL when they had no specific knowledge, when they had no reasonable belief of the infringement? That's what the court decided in 2016 judgment. Now coming to the second question, my dear friends, as posited in this case in 2016 in this appeal, basically the question reads, does proviso to section 81 override the safe harbor granted to intermediaries under section 79 of the IT Act 2000? Well, let me give you a little background about this issue, my dear friends. There is one section 81 under the IT Act 2000 which gives IT Act overriding effect over other laws. Whenever there would arise a question of information technology or the subject matter of information technology, IT Act has been provided with an overriding effect by purview of section 81, which reads that this act has an overriding effect over other laws prevailing for the time being in force, etc. But the same provision through its proviso reads that in the cases of copyright and patent conferred rights, this IT Act will not have an overriding effect. So the question comes that by adding a proviso to section 81, did the legislature wanted to oust or exclude the immunity provided or safe harbor granted to intermediaries under section 79 of the IT Act in the cases of online copyright infringement or for patent infringement? This is one proposition, one interpretation, possible interpretation of the proviso of 81. So does this proviso override the immunity or safe harbor granted under 79, or does it not override? These are the two propositions which we are confronted with right now, and the court was confronted with. If 81's proviso is read according to this first possible interpretation, that it overrides the safe harbor granted to intermediaries, then in that case no immunity shall be available to the intermediaries like Myspace who are alleged to have been involved into infringement of copyrighted content, because proviso reads that copyright and patent issues, or in the cases of copyright and patent issues, this law will not have an overriding effect. If we go by this first interpretation, then no liability shall be ever available to the intermediaries. But if we restrict the sweep of proviso to section 81 only, and we don't spread it any further to other provisions or other parts of this act, then in that case we see that there comes a different interpretation altogether, and which would be what? That immunity intermediaries safe harbor granted under the 79 will still remain available even if it is a case of copyright infringement or online copyright infringement. Now the court said, interestingly, you see, the court found that had the legislature been of the opinion to give this second interpretation to, the first interpretation to the proviso of 81, they would not have written that proviso, or they would not have incorporated this proviso under 81. They would have instead added it under 71, which would have served the purpose, which would have, ousted the safe harbor or any sort of immunity provided under 79 if it is a matter of copyright infringement, online copyright infringement. But since the legislature has not added it under 79, it shows that they had some other intent or some other purpose was fastened or fixed with the proviso of 81. And what was that purpose? That purpose can be comprehended and discerned if we read 81 and 79 together, and when we give them harmonious construction. By giving them the harmonious construction, we find that the proviso of 81 actually is complementary in nature and is not derogatory of what is written in other laws and in other parts of the act. This is what the court said in 2016. They said, no, the proviso does not override the safe harbor. It means the safe harbor or immunity provided under 79 is very much available to the intermediaries, even if they happen to, or even if they are alleged for online copyright infringement. That is, the safe harbor defense cannot be denied to the intermediary in the copyright actions or in the case of copyright actions or copyright infringement actions. So that was the harmonious construction derived by the court here, and which is actually the righteous construction. If we go by the logic of single judge provided in the previous judgment, he did not find it logical to provide a harmonious construction to 79 and 81. Rather, he said that 81's proviso takes away the safe harbor defense and intermediaries will have no defense at all. So had this been the intention of the legislature, they would have not included the proviso at all. Taking away the intermediaries safe harbor or taking away the intermediaries immunities means what? There are no immunities available to the intermediaries. Then what is the purport of 79 subsection 2 and 79 subsection 3 and 4 2? It becomes redundant altogether. The later part of 79 becomes redundant. If we go by the judgment of 2012, wherein it was found that it has an overriding effect, you see, we take away the safe harbor recourse, which is very much available to the intermediary, which has to be made available to the intermediary as per the international standards. But thankfully, the court in 2016 held that the proviso does not override the safe harbor, and this defense cannot be denied to the intermediary, even if it is a copyright infringement action, even if it is something which comes under the proviso of 81. Now let's see the third question, my dear friends, which reads, whether it was possible to harmoniously read and interpret section 79 and 81 of the IT Act and section 51 of the IT Act. I told to my viewers in the beginning that these 3-4 provisions are to be referred in one go in order to understand the nuances of this topic. I again urge to the viewers that these 3 provisions are very ticklish and lengthy, but you have to necessarily read and inculcate all these 3 provisions in order to finally, draw a command or grasp over this area. Otherwise, you won't be able to understand it fully. 79 provides immunities, and those immunities are available to the intermediaries in the enumerated situations of 79, and those immunities will not be available in some other enumerated situations of 79. It says when does one can get the benefit, when does one will not get the benefit. Both the situations have been covered under 79. 81 on the other hand says IT Act has an overriding effect, but the proviso of 81 saves copyright and patent, which are special statutes, and it allows the exercise of copyright and the Patent Act to be applied simultaneously in the cases of copyright infringement and patent infringement. 51 of the copyright, my dear friends, is a provision which lists out what? The acts which will constitute infringement, and as highlighted by me, that 51 1A reads or talks about the primary liability of the infringer for communicating the work to the public, and 51A2 talks about the secondary liability to be fastened to the infringer for allowing somebody or for allowing someone with the reasonable belief or with the actual knowledge that it is a copyrighted work of somebody else, but still for the profit you are allowing your premises or your place. As in this case, Myspace allowed its platform to the users, but in the present case Myspace had no actual knowledge, had no reasonable belief of the copyright infringement to take place. So when we come to the harmonious construction and interpretation of 79, 81 and 51 of the Copyright Act, my dear friends, the court findings are very important, and they are the key takeaways for you to understand that different laws are there to be taken recourse of in the cases of certain cases. Several laws can be invoked together in certain cases, but that does not mean that one law will become contrary to another and one law will not be applied if there exists another law which can also be invoked. Rather, the court said the right conferred under the IT Act are supplementary and not in derogation of the Patent Act or the Copyright Act. The proviso inserted under 81 meant only to permit copyright owners to demand action against intermediaries who may themselves post infringing content. I urge to my viewers to kindly pay keen attention to this portion of the judgment, that the proviso was inserted under 81 only to permit copyright owners to demand action against intermediaries who may themselves post infringing content. It was not incorporated to permit the copyright owners to demand action against those intermediaries who are just acting like intermediaries and not going into the capacity of, uploaders. They are not becoming the uploaders, they are rather remaining intermediaries. They don't upload the content on their own, they just facilitate the users by providing a platform to them. They never ever play any key role in initiation of that third party information which is to be disseminated and transmitted. They never modify or select the content to be transmitted. They never remain into the knowledge, actual knowledge of the content to be uploaded and about the copyright of that content to be uploaded on the internet. So in that case they cannot be made liable and this proviso will remain inapplicable. But in the case where the intermediaries who are themselves posting infringing content on the websites, they won't get the benefit of safe harbor and there will not exist any safe harbor for them for circumstances when content was third party or user generated. Well, as far as you see this judgment is concerned, my dear friends, I would like to draw your attention on one very important aspect or one very important paragraph of this judgment, which reads, the only logical and harmonious manner to interpret the law would be to read them together. As I said and emphasized, that reading the law together is the best way to come to a logical interpretation and a harmonious interpretation of that law. Not doing so would lead to an undesirable situation where intermediaries would be held liable irrespective of their due diligence, as happened in 2012 in the similar case when SCIL alleged infringement liability or copyright infringement against Myspace. Over there the judge concerned did not read the law harmoniously and made intermediary liable irrespective of their due diligence. They were diligent enough, rather in that case their due diligence was taken otherwise and they were made squarely liable for copyright infringement. As I said that it was ridiculous on the part of the court to say that user agreement provided by the Myspace or mechanism or measures opted by Myspace to curb, to filter, to block any wrong material, objectionable material to get uploaded on the platform. Those measures were taken as if they knew that some infringement is going to happen, and that because of those measures it was assumed or it was presumed by the court that they knew that some wrong material is being transmitted. That this is not the way to attribute knowledge on the party or on parties for that matter. This is not the logical way of fastening anyone with the liability for copyright infringement, because the section in relation to copyright infringement, that is section 51 of the Copyright Act 1957, explicitly says actual knowledge has to be there. If there is no actual knowledge, the party cannot be made liable. And surprisingly, I missed out a fact of 2012 case where you see SCIL provided Myspace with the voluminous information. They provided the repository of their repository of their songs which were lakhs in number actually. They said that these songs are being infringed by using the platform of Myspace, and secondary liability can be affixed to Myspace also for providing that space to the users. But they never categorically provided the specific instances and specific songs or the list of specific subject matters which were being violated. The court in that case held later in the division bench that this is not the right way to determine the liability. Now, my dear friends, I would like to come to a philosophical aspect behind this judgment and broader aspect behind this judgment, or you can say social angle behind the judgment. If we look carefully, what we are dealing with right now is relating to dissemination of information, is relating to dissemination and transmission of third party data, etc. on the internet. I explained to my viewers in my previous discourse that internet is a medium where the intermediaries are the key entities to smoothly or to facilitate the smooth functioning of the internet medium. If they stop functioning, internet will succumb completely and communication will stop, which is certainly a violation of constitutional right of expression in India. If every intermediary is expected to pre-screen every bit of information that is being uploaded on internet by the users of those intermediaries or their platforms, internet will not work that swiftly. Rather, I'll say it will stop functioning, because it is a medium where several people sitting in several jurisdictions and at several locations are uploading, seeing, viewing, streaming content and downloading the content. So the intermediaries in the internet medium, unlike in the physical medium, are not expected, cannot be actually expected to pre-screen everything or to see every information being uploaded. It's humanly impossible. Certain measures can be applied and obtained. For example, blockers or some filters can be fixed or attached to their systems or to the platforms, which would certainly filter out the objectionable material to an extent. Even those filters are not capacious enough to exclude everything, every objectionable or impugned information completely or fully. That cannot be done. It's impossible. This is the case of intermediaries, where they have been made available with the safe harbor, or you can say they have been made available with the immunities provided under 79. And to my understanding, this case is wonderful for societal benefit, because it allows the smooth functioning of the internet on the one hand and encourages the freedom of speech and expression on the other hand. Now, I would, before finishing it, I would quickly tell you about the 2018 judgment of the similar High Court, that is Delhi High Court, pronounced in the last month on perhaps 6th of November, wherein e-commerce entities, they are also intermediaries, but since they are e-commerce entities, you see, the court has held in a similar case like this that e-commerce entities shall be held liable for infringement of trademark if they do not pre-screen everything on their e-commerce platform before offering those things for sale on their platforms, because there are chances of the lay consumers getting duped and cheated or confused and deceived by buying wrong products on the website through them. So it is their sole responsibility to pre-screen whether the product that they are offering is a genuine one or not. If they fail to do so, despite that they are intermediary, they can still be held responsible. This is the latest development of last month, 2018, decided by the same High Court, that is Delhi High Court, and to my understanding that is also a very logical judgment. With this note, my dear friends, I take your leave, and we hope to see you in the next lecture in the next week. Thank you very much. Have a very good day.
Thank you, sir. Thank you so much for giving us this productive session. Thank you so much, dear friends, for watching us, and you can write your feedbacks as well as your questions at info.cec@nic.in. Once again, thank you for watching CEC Gurukul Live Lectures. Thank you, sir. Thank you once again.